Things that the U.S. Supreme Court has noted, and I think we all experience, is that scientific evidence has a real power to it. It's very persuasive, but when misunderstood, it has an equally powerful opportunity to mislead juries and judges to reach the wrong opinion. And we see that power working at the Innocence Project. It's great to walk into court and have a case in which there's a confession, where there's an eyewitness ID. The case looks really strong, and I can just say, listen, we've got hard science. We've got DNA testing. Let's test this rape kit. And whatever that eyewitness ID meant, unless you're in Philadelphia, whatever that confession meant is not going to matter, because we know that this semen, this evidentiary sample, is associated with a real person. The problem is that criminal defense lawyers, who are the ones who are responsible for questioning science, for raising these issues of reliability, are notoriously uninformed. In fact, most of the players in the criminal justice system, in terms of judges, prosecutors, and defense lawyers, really don't understand the science that's being presented. We deal with a lot of cases that are not even that old, and you'll have a DNA analyst who's testifying in court, and it becomes very clear from reading the transcript that the prosecutor, the judge, and the defense lawyer really don't understand what this scientist is saying, and everybody is simply just taking it for granted. And that's clearly not the ideal, and it's recognized in the NAS report that folks who are involved in this system don't really understand the science and can't evaluate it. We actually see this also when it's with the judiciary. There's a tendency to, when we don't understand something, we see this in psychology too, we tend to reject it. We tend to question the principles underneath it. And so somebody might be able to guess this quote about, is this pre or post Daubert? Pre, yes, this is an 1899 case. Actually, this judge, or this appellate panel, the Minnesota Supreme Court, rejected as unreliable germ theory. Although they ultimately did allow the scientific conclusion of, that this person died due to a personal injury. But so skepticism about science from the judiciary is not a new phenomena. Jurors, it's something very different. It's really, we see the jurors, they talk about the CSI effect, and there's a lot of controversy about whether that's real. But the reality is that juries do expect scientific evidence in these cases. And we see 46% saying we want it in every case. When you get to murder cases, 74%. So there is a real expectation among jurors that they're going to see this science. And I didn't go back through this to get the research that this is based on, but the enlightened Texas Court of Criminal Appeals recognizes that jurors don't understand what's being presented to them, and that when things get complicated, they really just go to the credentials. So again, we've got scientists appearing in the courtroom. The juries don't understand what these things are about, and it's our job as criminal defense lawyers, and really everybody involved in the system, to make sure that that just doesn't happen, that we're not all just nodding and smiling. And then again, we see this, prosecutors, based on these data, actually present more scientific evidence that they may not ordinarily do. Doing post-conviction work, one of the things that I was trained on was ineffective assistance of counsel is a mainstay of your practice. And it's unfortunate that that's the case, but it's one of the few ways that you can get new evidence into a case after a conviction, especially where you can do it in a way that there's a constitutional error associated. A lot of states may have a statutory new trial remedy, but that's not going to get you anywhere with a federal judge. You need a constitutional error, and really, there are very few ways you can get new evidence in. Ineffective assistance is the easiest path, and unfortunately, judges sometimes think these are inevitable, they're brought in every case. And that's, in a lot of ways, a subset of the fact that it's the only avenue to get this evidence, new evidence in. So this lays out the standard. One of the things you got to really pay attention to is the way the Supreme Court has looked at this. This is not like a small mistake. These have to be mistakes that the court views as really making it so that there was almost no lawyer available to you. Likewise, prejudice. The standard sounds pretty good in terms of undermining confidence in the outcome, but then you look at so serious as to deprive the defendant of fair trial. So there's a lot of wiggle room in that standard. Judges tend to be hostile to these kind of claims. This is some language from a case Richter that we'll talk about. It's never an easy task. It's all too tempting to second guess counsel's assistance. And so there's this view when we raise these cases a lot, where courts and other, the lawyer who is the trial lawyer will consider it almost akin to a negligence action. And that's the way the courts often phrase these things, but it's really not what the Constitution's about. The Constitution is about what happened for this defendant, not whose fault it was. But you'll see in some of these cases, the court really does look at, was there, in the heat of the moment, some explanation for why a lawyer did or did not do what they were supposed to, and the focus is on that and not on the reliability of the information that was ultimately provided to the jury. Sort of going criminal justice sections, criminal defense function standards. There's not a lot written on what lawyers are supposed to do with regard to experts, but the primary issue is the duty to investigate. I think we've all seen this. I was just looking at it in terms of where this probably comes from. I mean, going back to Powell versus State, which is essentially a judicial lynching type of a case. In 1932, the court was noting that there's a duty to investigate, and where you can sit Clarence Darrow next to a criminal defendant 5 minutes before trial, and they're not going to provide effective assistance, and that's the duty to investigate. The ABA standards are a little bit more specific with regard to experts, although it really doesn't get that close to the what exactly you're supposed to do. It's more about what you're not supposed to do. And it's respecting the independence of the expert, explaining their role in it, but again, and not trying to unduly influence those opinions by paying excessive fees or things like that. But there's not a lot of guidance on how do I actually work with this person, how do I meet the standard of care. I was looking around, there's not a ton in the case law either. This Sixth Circuit case is actually probably the best, and I can't claim credit for finding it. This was in Judge Gertner's order that we'll talk about at the end of my presentation. But this is a case where it was an arson prosecution. The defense lawyer hired an expert. The expert said that he agreed with the state's opinion as to arson, and the lawyer just took that at face value. And the court, when later presented with evidence saying this arson testimony was bogus, said, listen, you can't just hire somebody and believe whatever they say. You got to actually monitor what they're doing. You got to understand what that expert's doing. You got to understand the science. And we see this with a lot of defense lawyers. I can remember in a psychology context where a criminal defense lawyer I was working with in Texas talked about what this great psychiatry expert was, because you could just give him the case and put him on the stand and ask him a certain question, and he would go. You really didn't have to do any work on it. And that's obviously not what this case says you're supposed to be doing. You have to really understand what those experts are doing, what's the basis of their opinion, and really appreciate whether that's grounded in science. Going back to, there's really three main ineffective assistance of counsel cases that I want to talk about that are recent from the U.S. Supreme Court. Two are pretty bad. One is so-so. 2011 was a really bad year for ineffective assistance of counsel. Harrington versus Richter is a case involving a shooting. There was a self-defense claim, and the question was, there was no expert hired by the defense to look at this pool of blood. Relief was granted by the Ninth Circuit. The Supreme Court took it away, and the court essentially said, listen, the expert issue wasn't even brought up until the middle of trial. There was no expectation that this defense lawyer was going to have to deal with that issue. How can you blame that criminal defense lawyer for not hiring the expert when he didn't even know this was going to be an issue? And there the focus, again, was it reasonable for the lawyer in the circumstances? And the focus was not on what was the outcome for the defendant and what was the information provided to the jury. And so we see this as a real example of that negligence focus that makes these ineffective assistance of counsel claims often an ineffective remedy for miscarriages of justice. And you look at, there's some language that's difficult to deal with in terms of you don't have to get an expert for every one of the state's experts. One of the problems, obviously, in that is how do you understand whether or not you need an expert if you don't have somebody to consult with? And then likewise, where they're saying cross-examination can be good enough. That's true if you're informed about the science. And when there's technical issues that you don't understand and you haven't consulted with an expert, again, this kind of philosophy from the courts is not going to get your client any relief and is not going to remedy a miscarriage of justice. The other case that I don't have a slide on, but is case Pinholster, Cullen versus Pinholster, is not a guilt innocence case, it's a punishment phase case, and has similar issues with regard to the way the court's looking at the evidence. There you had a consulting expert that was hired by the defense for mitigation of the death penalty, and the consulting expert said, yeah, the guy doesn't have any psychological problems, and the only defense raised in that punishment phase was his mom, and the jury should feel sympathy for the mother. And there was this technical issue that the lawyer was looking at, and maybe the judge would have left all the state's evidence out. And so we're not going to second guess those game day decisions. And the court laid that out that way, despite the fact that the expert brought on post-conviction said, this guy's got serious psychological problems, and laid out a really tragic history type mitigation case. And again, you've got a situation where the court's not willing to second guess that judgment. He consulted with an expert. There's a statement that the lawyer spent 6 hours researching mitigation. 6 hours, come on. So that's Pinholster. This 2011 is kind of a low point. Recent decision, Hinton versus Alabama, is a good case. And there's some really nice language in this case talking about we have problems with forensics that have led to wrongful convictions. And in fact, looks at this, invalid forensic science contributes to these. But then when you actually look at the holding of Hinton, the court actually says, but we're not going to look at the substance. The issue is not the substance of the expert's opinion. The issue is that this lawyer made a mistake as to the law. In that case, there was a ballistics question, and the lawyer had hired a $500 expert who gave about $500 worth of opinion. And in post-conviction, there was stronger ballistics presented, and the court pigeonholed this in to say, well, the lawyer didn't understand the funding. If he had asked for more money, if he understood the law that said he was entitled to this more money, then he would have gotten these better experts, and that would have made that could have made a difference enough. So we're going to send it back for the court to look at. And I think Peter's going to discuss some of the issues with that case. So I'm not going to preempt it. But again, the sort of long and the short of it, and I'm trying to cut this a little bit more briefly so we can get out on time, is that ineffective assistance of counsel cases generally do not provide a true remedy for bad science, because these cases focus on the strategic decisions of lawyers who really don't know the science. They're adjudicated by judges who often don't know the science, and they are facing a very uphill battle where you have to show practically that the outcome would be different is how it's stated in some terms, lack of confidence, but you're looking at just short of a true miscarriage of justice case. Your ordinary average bad science in a criminal case is not going to raise these kind of issues. The other point, and just as a closing, that this issue with funding raises with Hinton versus Alabama is, what do you do when you have an expert who doesn't perform up to speed? We have a case called Ake versus Oklahoma that says that you have the right to all the tools necessary to present a defense. The judge has to give you funding in order to hire an expert. But the case law does not, case law does not associate that with the right to counsel. That's actually a fundamental due process right. And so you have an entirely different legal structure that you're dealing with when you're talking about an expert, even though they are retained by the lawyer. They're doing what the lawyer has asked them to do, and in a lot of ways there's an agency relationship between the lawyer and the expert. So again, there are ineffective assistance of counsel as a whole is not going to touch upon the performance of the expert either. And so that's a very narrow remedy. One moderate solution that we talk about, and again, it doesn't really address all the issues. When we talk about Daubert, the judge is supposed to employ a gatekeeping role. But in most times, that judge is acting sort of as a passive sentry. Only when the lawyers raise an issue as to it will the judge, keep the gate. That doesn't have to be the case. And this is Judge Nancy Gertner, who's now retired, but when she was on the bench, was concerned about the problem of trace evidence with the National Academy of Science report, and actually put in a standing order saying, this is concerning to me, this should be concerning to everybody, and putting lawyers on notice that these issues will come up, and when they do, you need to deal with them up front. And that's, in some ways, one small step forward, because we can have judges who can take a more active gatekeeping role, encourage these issues to be litigated up front. Again, when you deal with it up front, you're not trying to rely on these really ineffective remedies of ineffectiveness.